Many of the elements of this tragedy are familiar to the committee. BP was in charge of the drilling in the Gulf, has a history of prior spills from pipelines and other activities that cast doubt on whether the company has the commitment to the practice and the culture of safety necessary to protect the public. In March 2006, BP was responsible for the worst spill in the history of oil development on Alaska's North Slope, which was the subject of discussion and inquiry in this committee. The spill went undetected for 5 days. BP ignored 4 alarms on its system indicating that there was a leak. The federal investigation established that BP had not established programs for required maintenance, that is, cleaning with pigs, or programs for internal maintenance using smart pigs on the pipeline. Pipeline and Hazardous Material Safety Agency ordered BP to replace the lines. Admiral Barrett, later retired admiral of the Coast Guard, later put in charge of the Pipeline Safety Management Agency, said, quote, "I continue to find that the presence of hazardous conditions on 3 of these pipelines managed by BP would likely result in serious harm to property or the environment." He issued 3 corrective action orders to BP. Which took them quite some time to comply. And I have a complete timeline. I won't go into that at this point. When BP obtained its approval for safety and response plan required for drilling in the Gulf, BP claimed that if there was a spill, it would not have an environmental impact because BP would rely upon, quote, "industry-wide standards for using proven equipment and technology to respond to the spill." Almost a month has passed. The response plan and its proven equipment and technology have failed to stop most of the continuing oil discharge or to contain most of the oil already discharged. BP has harnessed impressive scientific and technological experience to drill at great depths in the sea, and you have to wonder why they hadn't harnessed similar science and technology to anticipate failure, to install redundancy to prevent failure, and practices to clean up after an oil spill. On the government side, similarly, there is a very disturbing lack of dedication to safety, excessive reliance on the industry to police itself, going back more than 2 decades of government experience. The Minerals and Management Service of the Department of Interior, in charge of ensuring the safety of offshore drilling, has a dual mandate: to promote and to regulate. Promote the government's financial relationship with the drilling industry and regulate the safety of the industry. That combination creates inevitable conflicts, and those can undermine safety. In regulation of offshore drilling, Minerals Management Service has fallen way short of the commitment needed for effective oversight of offshore drilling. They have shown a disturbing failure to regulate blowout preventers, a critical part of the BP plan to contain or to prevent a spill. Minerals Management Service was aware that in the last recent years, several failures, several blowout preventer failures played a role in at least 14 accidents. In 1 year, there were 114 blowout preventer failures. But the Minerals Management Service relied totally on the industry to ensure effectiveness of blowout preventers. At the Marine Board of Inquiry for the accident, the co-chair of that panel reported testimony of an expert witness quote, is designed to industry standard, is manufactured by the industry, and installed by the industry, with no government witnessing or oversight of construction or installation. Well, that brings back to painful memory hearing in this committee in which excessive deference to a regulated industry was called to our attention. But the Coast Guard's contract for its deepwater procurement program, we found that the Coast Guard allowed a company who had the contract for major vessel procurement and extension to also play a critical role, major role in certifying the design of the vessel. So the Coast Guard, as Minerals Management Service, as FAA before it, were relying on industry to design the product, build the product, certify its safety. And Chairman Cummings, chair of the Coast Guard Subcommittee, had an 11-hour hearing in this committee that established all of those facts, resulting in legislation that has changed the practice of the Coast Guard. We also learned in hearings conducted by Mr. Costello, chair of the Aviation Subcommittee, that FAA policy was to consider regulated airline as its customer, to go to great lengths to keep the customer satisfied with the inspectors who are regulating it. The result of the hearing caused the FAA to significantly change its practices and change personnel as well. And now we're seeing a change of culture in the FAA on oversight of safety. We've developed legislation as a result of those experiences, and I expect we'll do the same after we have plumbed the total causes of this incident in the Gulf. Delegation of responsibility for the safety of the drilling unit, delegated out to the Republic of the Marshall Islands, where that drill rig was registered. Under U.S. law, we give considerable deference to safety regulation by the country of registry in aviation and maritime. There's one reason that ship owners register their ships in flag of convenience countries like the Marshall Islands. They want to save money by avoiding the safety and liability standards required by countries such as the United States. Coast Guard witnesses before the Marine Board of Investigation on the Deepwater Horizon accident testified that a Coast Guard inspection of a U.S. flag mobile offshore drilling unit takes 2 to 3 weeks. But the safety examination of a foreign flag offshore drilling unit, such as the Deepwater Horizon, takes 4 to 8 hours. Obviously, nowhere near as thorough and detailed an investigation and certification or recertification as we do of our own equipment. Given the magnitude of the spill in the Gulf, we need to review the causes of the spill, as well as the broader question of the adequacy of procedures for ensuring that drilling is safe and does not endanger the environment. This is not a hearing about whether or not to drill, but how you go about the procedures, how you assure the public safety, and how the interest of the broader public is protected to ensure that this type of disaster does not happen again. About 2 weeks ago, I circulated an idea, without making it public, that I thought the best approach to the fundamental causes would be a challenger-type commission. I served on one such commission, Pan Am 103, requested by then President George Bush I, which resulted in the first aviation safety legislation enacted in this country, preceding that of September 11, 2002. After the September 11, 2001, passed it in 2002. So I think the President's initiative toward a commission is a sound idea, and we may even have to introduce legislation to further that cause.